Before we begin, a quick and important disclaimer. This video is for educational and entertainment purposes only and does not constitute professional legal, career, or financial advice. The employment trends and salary figures discussed are based on historical data and industry reports, which are subject to change. Every individual's career path is unique, and potential outcomes vary based on location, experience, and market conditions. You should conduct your own due diligence and consult with a qualified professional before making any significant career or legal decisions. In the next 10 minutes, everything you think you know about the stability of the American legal profession is going to be challenged. We are witnessing a massive silent shift in the fabric of the U.S. economy, where one specific sector is currently outperforming traditional corporate law in ways that most analysts didn't see coming. While major tech firms and Silicon Valley giants are trimming their legal departments, the demand for family law specialists, specifically divorce attorneys, is reaching a fever pitch. There is a specific reason why certain states are seeing a 40% spike in filings, and if you understand the data behind these employment trends, you will understand the future of the American service economy. We are diving into a world where high conflict resolution meets recession-proof job security, and the numbers are staggering. This deep dive solves the most pressing question for aspiring legal professionals and career pivoters in 2026. How do you find a career path that is not only resistant to economic downturns, but actually thrives during periods of social and financial volatility? We are going to break down the geographic hotspots where attorney demand is highest, the specialized skill sets that are commanding six-figure premiums, and the historical trends that prove this isn't just a temporary surge, but a permanent restructuring of the legal market. When we look at the employment landscape of the United States today, we have to address the elephant in the room: the volatility of the white-collar job. For decades, the gold standard for a young law student was big law, the massive multi-city firms handling mergers and acquisitions. But mergers stop when interest rates climb. Acquisitions freeze when the market turns bearish. Divorce, however, does not follow the traditional business cycle. In fact, historical trends suggest that marital dissolution often maintains a steady, if not inverse, relationship with economic health. This creates a unique employment profile for the divorce attorney. Unlike a patent lawyer who might be tied to the R&D budget of a single corporation, a divorce attorney's client is the American household, and that market is over 130 million strong. To understand why the employment trend for divorce attorneys is currently on an upward trajectory, we have to analyze the complexity multiplier. 20 years ago, a divorce might involve a house, 2 cars, and a savings account. Today, an attorney in the U.S. is dealing with a landscape of digital assets, cryptocurrency portfolios, multi-state remote work arrangements, and complex stock option packages. This complexity has moved the profession from a volume-based practice to a high-value, specialized consultancy. As the complexity of the average American's financial life increases, the man-hours required per case increase. From an employment perspective, this means firms are not just looking for more attorneys. They are looking for more billed hours per case, which drives up the demand for associate-level support and paralegal staff. Let's look at the geographic data. If you are tracking employment trends, you cannot look at the U.S. as a monolith. You have to look at the litigation corridors. Data shows that states with high internal migration, such as Florida, Texas, and Arizona, are experiencing a vacuum in legal services. When thousands of people move to a new state, they bring their complex domestic histories with them. However, they are moving into jurisdictions with different statutes regarding community property and equitable distribution. This creates a massive employment opportunity for attorneys who can bridge the gap between different state laws. For example, a family law firm in Austin, Texas, is currently competing for talent with firms in New York because the sheer volume of high-net-worth individuals moving to the Sun Belt has outpaced the local supply of qualified litigators. Furthermore, we must examine the shift in legal tech integration. There is a common misconception that AI will replace the divorce attorney. The reality reflected in recent employment data is the opposite. Firms are hiring tech-enabled attorneys who use diagnostic tools to streamline discovery, allowing them to take on a higher volume of cases without decreasing their accuracy. This has led to a new trend in the employment market: the hybrid practitioner. These are individuals who possess both the emotional intelligence required for high-stakes mediation and the technical proficiency to navigate modern forensic accounting. Step by step, the career path for a divorce attorney in the current U.S. market has shifted. It used to be a linear progression from law school to a small boutique firm. Now we see a trend of niche-down employment. We are seeing the rise of the gray divorce specialist, attorneys who exclusively handle the dissolution of marriages for those over the age of 55. Why is this a trend? Because the baby boomer generation holds the largest share of household wealth in American history. As this demographic enters a new phase of life, the legal requirements for dividing pension plans, 401ks, and long-term care provisions require a level of expertise that a generalist simply cannot provide. This specialization is driving a premium in salary trends, with specialists in this niche often seeing a 20 to 30% higher starting compensation than general family law practitioners. We also have to consider the institutionalization of family law. Historically, divorce law was the domain of the solo practitioner, the lawyer with a small office on Main Street. But the trend in 2026 is toward the mega-firm model for family law. Private equity firms have begun to take notice of the steady cash flow generated by domestic relations firms. This is changing the employment structure entirely. Instead of being a partner in a three-person firm, the modern divorce attorney is often an employee of a multi-state legal corporation. This provides better benefits, more structured career ladders, and more stability, making the field more attractive to top-tier law school graduates who would have previously headed for Wall Street. The data also points to a significant trend in alternative dispute resolution, or ADR. Employment for collaborative divorce attorneys is growing faster than for traditional trial litigators. The American consumer is becoming more cost-conscious and privacy-oriented. They want to avoid the public spectacle of a courtroom. Consequently, firms are aggressively hiring attorneys with certifications in mediation and collaborative law. This shift changes the workday of the attorney from one of adversarial litigation to one of strategic negotiation. This change in the nature of the work is actually helping with attorney retention, a major metric in employment trends. By reducing the burnout associated with high-conflict court battles, firms are keeping their talent longer, leading to a more experienced and stable workforce. In this deep dive, we are going to look at the specific case studies of firms in the Pacific Northwest that have successfully pivoted to a subscription-based or unbundled legal service model. This is a revolutionary trend in employment because it allows attorneys to serve a demographic that was previously priced out of the legal market, the middle-class American. By offering specific services like document review only or mediation coaching, these firms are opening up a massive new market, which in turn creates a demand for a new type of legal professional, the legal consultant. We will analyze the historical correlation between no-fault divorce laws and the expansion of the legal labor market. We will look at how the 1970s saw a boom in employment that plateaued, and why the digital asset revolution of the 2020s is creating a second golden age for this profession. This isn't just about people breaking up. It is about the redistribution of assets in an increasingly complex society. If you want to understand where the money, the jobs, and the influence will be in the legal sector for the next decade, you have to look at the divorce attorney. The trends are clear, the data is undeniable, and the shift is just beginning. To truly understand the massive scale of the divorce law employment sector in 2026, we have to examine the specific economic mechanics that drive law firm hiring. When we talk about employment trends, we are really talking about the intersection of social behavior and capital. Imagine a professional named Sarah, a mid-level associate at a firm in Chicago. In previous decades, Sarah's value was determined by her ability to file motions and attend hearings. In 2026, her value, and the reason her salary has seen a historical trend of steady increases, is her ability to navigate the forensic digital discovery phase. This is where the employment market is currently exploding. Law firms across the United States are currently in a talent war for attorneys who understand decentralized finance. Consider a case study from early 2025 in Southern California. A high-net-worth dissolution involved a spouse who had hidden significant assets in various cold storage crypto wallets and non-fungible tokens. The firm that won that case didn't just have a good orator. They had a specialized divorce attorney who functioned as a digital detective. This specialized skill set is creating a two-tiered employment market. On one level, you have the traditional practitioner, and on the other, you have the high-stakes asset recovery specialist. Historical trends show that those in the latter category are seeing recruitment bonuses that were previously reserved for corporate tax attorneys. This brings us to the actual numbers behind the growth. The Bureau of Labor Statistics has consistently pointed toward a steady demand for legal services, but within the subset of family law, we are seeing a unique phenomenon known as the silver splitter surge. Historically, divorce rates were highest among younger couples. However, in 2026, the data shows a significant increase in filings among couples over the age of 60. From an employment perspective, this is a goldmine for new attorneys. Why? Because these cases are rarely about child custody. They are exclusively about complex asset division, Social Security benefits, and the unwinding of multi-decade joint ventures. The billable hours required for a gray divorce are often triple that of a standard dissolution, because the discovery process involves decades of financial history. Furthermore, we must analyze the shift in firm structure. The old model of the solo practitioner is being eclipsed by the regional powerhouse firm. These are firms that employ 50 to 100 attorneys across multiple states. This shift is creating a corporate-style career path within family law. In 2026, an entry-level attorney isn't just learning how to file a petition. They are being trained in a multidisciplinary approach that includes psychological mediation, financial planning, and tax strategy. This institutionalization means that employment is no longer just about the lawyer. It includes the rise of the divorce financial analyst and the forensic accountant as permanent fixtures within the legal payroll. If you are looking at the jobs of the future, you have to see that the modern divorce firm is becoming a one-stop shop for life restructuring. Let's look at the impact of the remote work revolution on these employment trends. As of 2026, millions of Americans are working for companies based in Delaware while living in Montana or Florida. This has created a jurisdictional nightmare that requires more man-hours to resolve. A divorce attorney today might have to argue which state's laws apply to a marital home when the couple lived in 3 different time zones during their marriage. This jurisdictional complexity is driving a 15% increase in the need for research associates and junior counsel, who specialize in conflict of laws. For the U.S. workforce, this means that geographic location is becoming less of a barrier to entry. We are seeing attorneys in lower cost of living areas being hired by high-end firms in New York and Los Angeles to handle the heavy lifting of research and drafting, creating a domestic outsourcing model that was non-existent 10 years ago. The concept of the recession-proof career is often discussed, but divorce law provides one of the most robust examples in the modern economy. Historical trends indicate that during economic downturns, the nature of divorce changes, but the volume remains relatively stable. In a booming economy, people divorce because they feel financially independent enough to leave. In a crashing economy, the stress of financial loss often leads to the same outcome. From an employment standpoint, this creates a countercyclical hedge. While real estate attorneys might see their caseloads vanish overnight during a housing bubble burst, the divorce attorney's docket remains full. This stability is why we are seeing a record number of law students in 2026 selecting family law as their primary concentration, a sharp departure from the corporate-heavy focus of the early 2010s. Imagine if a law firm operated like a tech startup. In 2026, this is becoming a reality. The employment of legal operations managers within family law firms is a skyrocketing trend. These professionals are not lawyers. They are efficiency experts hired to optimize the workflow of a divorce case. They use predictive analytics to determine how long a case will take and what the potential outcomes might be based on the presiding judge's history. This integration of data science into the legal field is creating a new category of high-paying jobs that sit right alongside the attorneys. The data suggests that firms using these legal ops managers are able to handle 40% more cases per year, which in turn necessitates the hiring of more associate attorneys to manage the increased volume. It is a self-sustaining cycle of growth. We also need to discuss the role of public policy in driving employment. In 2026, several U.S. states have introduced new legislation regarding the transparency of digital assets in domestic proceedings. Every time a new law is passed, it creates a requirement for specialized knowledge. Law firms respond to this by creating new departments. We are seeing the emergence of the Digital Asset Compliance Officer within family law practices. This individual ensures that all disclosures are compliant with the latest state and federal regulations regarding privacy and encryption. This isn't just a job. It's a new pillar of the legal economy. To understand the depth of this shift, we have to look at the case study of a mid-sized firm in Charlotte, North Carolina. In 2024, they had 10 attorneys and focused on general litigation. By 2026, after pivoting exclusively to high-net-worth family law, they have expanded to 35 attorneys and have a dedicated team for international asset tracing. Their revenue has tripled, not because the divorce rate tripled, but because the value and complexity of each case skyrocketed. This reflects a broader trend across the United States. the professionalization and scaling of the divorce industry. The compensation models are also evolving. We are moving away from the strict hourly billing toward a value-based pricing model in certain elite firms. This change incentivizes efficiency and results, which has led to a change in the type of personality being hired. Firms are no longer looking at the traditional grinder who wants to bill 2,500 hours a year. They are looking for the strategic closer who can resolve a multi-million-dollar dispute in 6 months through expert mediation. This shift in hiring criteria is fundamentally changing the demographic of the American legal workforce, attracting more professionals with backgrounds in business and psychology. But what happens when the legal system itself begins to automate? There is a growing fear that DIY divorce apps will eliminate the need for attorneys. However, the 2026 data shows that while low-income, no-asset divorces are moving to apps, this has actually freed up the professional labor market to focus on the high-margin, complex cases that require human judgment. It's a classic example of market stratification. The employment trend for attorneys is shifting toward the top end of the market, where the stakes are too high for an algorithm to manage. This is creating a concentration of wealth and talent within the top 20% of family law firms. As we look at the trajectory for the remainder of 2026 and into 2027, the focus is shifting toward the international divorce attorney. With more U.S. citizens marrying foreign nationals and holding assets in multiple countries, the need for attorneys with a grasp of international treaties and the Hague Convention is at an all-time high. This is the new frontier of employment. It requires a level of sophistication that goes beyond local statutes and into the realm of global diplomacy. But who are the people actually winning in this new economy? Is it the veteran partners? Or is there a new breed of legal entrepreneur taking over the market? And more importantly, what are the specific red flags that indicate a firm is failing to adapt to these trends? In the next part, we are going to look at the dark side of this boom, the burnouts, the ethical traps, and the massive firm collapses that happen when you try to scale too fast without the right infrastructure. We are also going to reveal the specific state where divorce attorneys are currently making more than corporate partners at the world's largest firms. The answer will surprise you. The state currently disrupting the traditional legal hierarchy is Florida. While many would assume the highest compensation for divorce attorneys would be found in the glass towers of Manhattan or the entertainment hubs of Los Angeles, Florida has emerged as the premier market for domestic relations experts in 2026. This isn't accidental. It is the result of a perfect storm of tax laws, demographic shifts, and the recent elimination of permanent alimony in the state. This legislative change, which occurred a few years ago, triggered a massive wave of litigation that has yet to subside. Historical trends in the Florida legal market show that when major statutes are overhauled, the demand for senior-level litigators who can interpret new case law spikes. In the current market, a lead partner in a top-tier Miami or Palm Beach family law boutique is often generating more in annual billables than a junior partner at a global corporate firm. The reason? High-stakes finality. In corporate law, a deal might fall through and the fees are capped. In a high-net-worth Florida divorce involving a business mogul or a retired executive, the litigation is essential, and the fees are a secondary concern to the protection of the asset base. To understand the dark side of this boom, we have to look at the ethical traps and the burnout epidemic that is currently reshaping the employment landscape. Imagine a character named David, a high-achieving attorney in Seattle. David is part of the first generation of lawyers to manage a 100% digital caseload. In 2026, the expectation of immediate responsiveness has created a 24-hour work cycle. Historical trends in the legal profession have always pointed toward high stress, but the current divorce market is unique. Because these cases involve the most intimate and volatile aspects of a client's life, the emotional labor is immense. We are seeing a trend where firms are losing top-tier talent not to competitors, but to total career exits. This has forced a radical change in the employment packages offered by smart firms. To prevent burnout, we are seeing the rise of the sabbatical clause in family law contracts. Modern firms are now offering mandatory quarterly mental health breaks to ensure their litigators don't collapse mid-trial. The risk of scaling too fast is another critical factor. We have seen case studies of firms in the Northeast that attempted to use the venture capital model to dominate the family law space. They hired 50 associates in 18 months, aiming for a high-volume, tech-driven approach. However, they ignored the fundamental reality of the American legal system. The courtrooms are still a bottleneck. You can automate the paperwork, but you cannot automate the judge's calendar. When these firms couldn't move cases through the system fast enough to satisfy their investors, they began to cut corners on discovery. The potential outcomes of this are devastating. In 2025, a major regional firm in Massachusetts faced a massive malpractice suit because their automated system missed a hidden offshore account in a high-profile case. This led to a firm-wide collapse, demonstrating that while technology is a tool, the human element of thorough legal scrutiny remains the primary value proposition of an attorney. Let's look at the financial architecture of the modern firm. In 2026, we are seeing a shift away from the traditional partnership track toward a more diverse compensation structure. Historical trends show that young attorneys are increasingly prioritizing equity and profit sharing over a high base salary. Firms are responding by offering non-equity partnerships much earlier in a career. This is a strategic move to lock in talent. If an associate is managing a book of business worth $2 million in billables, the firm knows that associate could easily walk across the street and start their own boutique. To combat this, the employment contracts of 2026 are filled with complex non-compete and non-solicitation clauses that are currently being tested in the courts. This legal tug-of-war over talent is one of the most significant employment trends in the country. Now, consider the role of the forensic social media analyst. This is a job title that barely existed a decade ago, but is now a standard hire for any divorce firm with a marketing budget over $500,000. In 2026, every check-in, every photo, and every comment made on a social platform is a potential piece of evidence. The firms that are winning in the employment market are those that have built out internal departments to handle this data. They aren't just hiring lawyers, they are hiring data miners who can find the needle in the digital haystack. This has created a new entry point for paralegals and legal assistants who have a background in digital forensics, rather than just clerical work. The imagine if scenario for 2026 is this. Imagine if your entire financial history was being analyzed by an AI trained specifically on the divorce settlements of the last 50 years. This is the reality for many high net worth individuals today. Attorneys are now using outcome prediction software to advise their clients on whether to settle or go to trial. From an employment perspective, this means the modern divorce attorney needs to be as comfortable with a data dashboard as they are with a legal brief. Historical trends suggest that the attorneys who resist this technology see their billable rates stagnate, while those who embrace it are able to command premiums because they can offer a higher degree of certainty to their clients. We must also analyze the impact of the gig economy on divorce law employment. As more Americans move toward freelance and contract work, the traditional methods of calculating child support and alimony are becoming obsolete. There is no steady paycheck to garnish. This has created a demand for income imputation specialists. These are attorneys or financial experts who can look at a person's lifestyle and expenses to impute what their actual income should be. This is a labor-intensive process that requires a deep dive into bank statements, lifestyle audits, and industry benchmarks. It is a niche that is currently underserved, meaning those who specialize in it have a massive advantage in the job market. As we move deeper into 2026, we are also seeing the rise of the virtual law firm in the family law sector. These firms have no physical office. They use encrypted video conferencing and cloud-based case management systems. This model drastically reduces overhead, allowing these firms to pay their attorneys a higher percentage of their billables. For the U.S. public, this means more competitive pricing. For the attorney, it means a level of geographic freedom that was unthinkable in the legal world just a few years ago. You can be a top-tier divorce litigator for a firm in San Francisco while living in the mountains of Colorado. This is fundamentally shifting the talent pool away from the major cities and toward wherever the best quality of life can be found. The ethical considerations of these employment trends cannot be ignored. As firms become more corporate and data-driven, the pressure to maximize lifetime client value can conflict with the attorney's duty to provide the most efficient resolution. We are seeing a rise in ethics officers within large family law groups, individuals whose sole job is to ensure that the firm's pursuit of growth doesn't cross into predatory billing practices. This is a self-regulatory trend that is essential for the long-term health of the profession. But what about the clients themselves? How is the changing face of the American family affecting the skills a lawyer needs to get hired? We are entering an era where non-traditional family structures are the norm. From multi-parent households to complex surrogacy agreements, the divorce attorney of 2026 is often untangling relationships that the law wasn't originally designed to handle. This requires a level of creative lawyering that is rare and highly compensated. As we look toward the next phase of this analysis, we have to ask, what happens when the bubble bursts? Is the current surge in divorce law employment sustainable? Or are we looking at an oversaturated market that is about to experience a massive correction? And what is the one specific technological advancement that is currently being tested in a small court in Ohio that could potentially make the entire discovery process happen in seconds rather than months? The implications for the workforce are profound. If the hours disappear, what happens to the billing model that has sustained the legal profession for a century? We are about to look at the efficiency paradox and how it is forcing the smartest firms to completely reinvent their revenue streams before it's too late. The efficiency paradox is the single most dangerous threat to the traditional legal business model in 2026. For over a century, the billable hour has been the bedrock of attorney compensation. If a task took 10 hours, the firm billed for 10 hours. But now, imagine a character named Marcus, a junior associate in a high-volume firm in Columbus, Ohio. Marcus is currently testing a generative discovery protocol that can scan 10,000 pages of financial records, identify discrepancies in offshore tax filings, and cross-reference them with local property records in less than 90 seconds. Historically, this task would have required 3 paralegals and 2 junior associates working for a month. From an employment perspective, this creates a crisis. If the machine does the work in seconds, how does the firm justify the bill? This technological leap is forcing a total reinvention of revenue streams. We are seeing a shift toward flat-fee project management for specific phases of a divorce. Instead of billing for time, firms are billing for the value of the outcome or the complexity of the asset recovery. Case studies from early 2026 show that firms adopting this value-based model are actually seeing higher profit margins than those clinging to the hourly clock. Why? Because it incentivizes the attorney to use the most advanced tools to reach a resolution faster. For the U.S. legal workforce, this means that the traditional grinder who succeeded simply by working 80 hours a week is being replaced by the strategic technologist who knows how to leverage high-end software to achieve a result in 20. Let's dive into the specifics of that Ohio court experiment. In a small jurisdictional pilot program, the court introduced a mandatory automated disclosure system. In this system, both parties in a divorce are required to link their banking, investment, and crypto APIs directly to a court-monitored dashboard. This removes the months of back-and-forth discovery and hiding of assets. The implications for employment are profound. If the administrative heavy lifting of discovery is automated by the court itself, the divorce attorney's role shifts entirely toward strategy and emotional advocacy. We are seeing a trend where firms are hiring fewer document reviewers and more high-level negotiators. This is a massive contraction in the entry-level labor market, but a significant expansion in the demand for senior-level strategists. Historically, the legal profession has been slow to change, but the current year has brought about the rise of the divorce architect. This is a new role within the firm that combines the skills of a financial planner, a tax strategist, and a legal counselor. Imagine if you were going through a dissolution and instead of just a lawyer, you had a professional who could model the next 20 years of your financial life based on 3 different settlement scenarios. This is the level of service that modern clients are demanding. Consequently, firms are aggressively recruiting professionals from the wealth management and accounting sectors. The employment market for divorce law is no exclusive to JD holders. We are seeing an influx of MBAs and CFPs entering the family law space to fill these advisory roles. But what happens if the market becomes oversaturated? With more law students than ever moving into family law due to its perceived stability, we are beginning to see the first signs of a mid-market squeeze. In cities like Denver and Atlanta, the sheer number of boutique firms has led to a price war for standard, uncontested divorces. This is where the bubble might burst. For a professional to survive in 2026, they have to move either upmarket into high-complexity cases or toward a high-efficiency volume model. The middle ground, the generalist who does a bit of everything, is disappearing. Data from the first quarter of 2026 suggests that mid-sized generalist firms are seeing a 12% decline in realization rates, while specialized boutiques are seeing a 20% increase. We also have to analyze the impact of the mental health and wellness movement on law firm hiring. In previous decades, a divorce attorney was expected to be a shark, cold, calculating, and tireless. Today, the case studies of the most successful firms in the U.S. show a focus on emotional intelligence or EQ. Firms are now using psychological testing during the hiring process to ensure their attorneys can handle the high-conflict nature of the work without succumbing to secondary traumatic stress. This is not just about being nice. It's a business strategy. An attorney who can keep a client calm and focused on the facts moves the case faster and reaches better settlements. This shift is attracting a new demographic to the field. Individuals who might have previously gone into psychology or social work are now finding that they can have a more direct impact on people's lives as family law advocates. The geography of employment is also being redefined by the rise of the interstate practitioner. With the increase in remote marriages and fragmented asset holdings, we are seeing the emergence of attorneys who hold bar licenses in 3 or 4 different states. This allows them to handle the entire dissolution of a couple that might have a primary residence in New York, a vacation home in Florida, and business interests in Delaware. These multi-jurisdictional experts are the highest-paid individuals in the field, often commanding retainers that rival those of top corporate defense teams. Step by step, we are seeing the deconstruction of the traditional law office. Imagine a firm that has no receptionists, no leather-bound books, and no mahogany desks. Instead, they have a secure server room and a team of attorneys working from home offices across the country, linked by a proprietary project management system. This model is becoming the standard for the new generation of legal entrepreneurs. It allows for a level of agility that traditional firms cannot match. When a new legal trend emerges, like the recent shift in how equity compensation is treated in California divorces, these agile firms can update their entire workflow and client strategy overnight. Historical trends also show a rising correlation between political shifts and family law demand. Changes in federal tax law regarding the deductibility of legal fees and the treatment of alimony have created waves of work as existing agreements need to be modified. In 2026, the potential outcomes of a pending Supreme Court case regarding the interstate recognition of specific domestic partnerships are already driving a surge in preemptive legal consultations. The divorce attorney is increasingly becoming a proactive advisor, helping clients structure their lives to avoid future litigation, rather than just responding when things go wrong. The role of the forensic appraiser is also expanding. In an era where a single social media account or a digital brand can be worth millions, the valuation of intangible assets has become a primary battlefield in divorce law. Firms are now employing full-time brand valuation experts. Consider a scenario where a mid-level influencer is getting divorced. How do you value the future earnings of an account with 2 million followers? How do you divide the intellectual property of a digital course? These are the questions that are providing high-paying jobs for a new wave of legal and financial professionals. But even with all this growth, there is a looming shadow. The rise of the private judge is a trend that is taking the most lucrative cases out of the public court system and into private arbitration. While this is great for the wealthy, it is creating a two-tiered system of justice. From an employment standpoint, this is creating a massive demand for retired judges to act as private neutrals. This is the ultimate career capstone for a family law professional, moving from the bar to the private bench, where they can earn triple their previous salary while working a fraction of the hours. As we move into the next part of this deep dive, we are going to look at the specific marketing strategies that these viral firms use to capture the US market. How are they using short-form video and psychological profiling to find clients at the exact moment they decide to leave? And more importantly, we are going to look at the hidden risks of the consolidation phase. What happens when your local family law firm is bought by a multinational conglomerate? The answer involves a massive shift in how legal ethics are being rewritten for the digital age. We are also going to reveal the one specific skill that is now more important than winning in court. If you don't have this, your law degree might be obsolete by 2030. The specific skill that is now more important than winning in court is high-stakes emotional mediation. In 2026, the U.S. legal landscape has reached a tipping point where the courtroom is no longer the primary theater of operation for the elite divorce attorney. Instead, it is the boardroom and the private conference suite. Historical trends show that as court backlogs in major metropolitan areas like Atlanta and Houston stretch into 18-month waits, the ability to resolve a dispute without ever seeing a judge has become the most valuable asset a legal professional can possess. If you cannot settle a case, you are a liability to your firm's realization rate. Clients in 2026 are increasingly sensitive to the burn rate of a protracted legal battle, and the attorneys being promoted to partner are those who can de-escalate a conflict before it consumes the marital estate in legal fees. To understand how this looks in practice, let's analyze the marketing strategies of the new viral law firms. These are the firms that have moved away from traditional billboard advertising and toward algorithmic client acquisition. Imagine a professional named Robert who lives in a high-income suburb of Philadelphia. In 2026, Firms are using psychological profiling to identify individuals like Robert, who are in the pre-filing stage. They aren't looking for the word divorce in a search bar. They are looking for shifts in consumer behavior, such as a sudden interest in individual financial planning or real estate valuations in different zip codes. By the time Robert actually clicks an ad, he is being met with highly targeted short-form video content that addresses his specific fears about asset protection and custodial rights. This level of precision in marketing is creating a new category of employment, the legal growth hacker. These are professionals who bridge the gap between data science and legal ethics, ensuring that the firm's funnel is always full of high-value leads. Case studies from firms in the Pacific Northwest show that this data-driven approach has a secondary effect on employment. Because these firms can predict their caseload months in advance, they can staff up with surgical precision. They are no longer hiring based on a gut feeling. They are hiring based on a projected lead-to-ligation ratio. This has led to the rise of the specialized intake department. In these modern firms, the first person a client speaks to is not a receptionist, but a highly trained legal strategist whose job is to triage the case. This professional assesses the complexity of the digital assets, the volatility of the custody situation, and the potential for a peaceful resolution. This ensures that the attorneys are only spending their time on cases that match their specific expertise. This stratification of labor is a major historical trend that is professionalizing the industry. However, we must address the hidden risks of the consolidation phase. In 2026, we are seeing a massive wave of mergers and acquisitions within the family law sector. Large, multinational legal conglomerates are buying up local boutique firms in a trend similar to what happened in the medical and dental industries a decade ago. While this provides the local firm with massive resources and better technology, it creates a significant tension with traditional legal ethics. For example, if a conglomerate owns the 3 largest firms in a single city, how do they manage the conflict of interest if a husband and wife each seek representation from a subsidiary of the same parent company? This is forcing a rewrite of the American Bar Association's model rules of professional conduct. From an employment perspective, this consolidation means that many attorneys are finding themselves working for a corporate board rather than a senior partner. The potential outcomes of this shift include higher standardized salaries, but a significant loss of autonomy for the individual practitioner. Let's look at the imagine if scenario regarding the one skill that makes a law degree potentially obsolete by 2030. Cross-disciplinary financial engineering. In 2026, a divorce attorney who only knows the law is effectively a clerk. Imagine if a client presents a portfolio that includes fractionalized real estate interests, tokenized private equity, and automated revenue-sharing agreements from a digital platform. If the attorney cannot read a smart contract or understand the tax implications of an exit event in a startup, they cannot effectively represent their client. This is why we are seeing a surge in law firms hiring technical subject matter experts, or TSMEs. These individuals don't have law degrees, but they sit at the right hand of the attorney during every negotiation. If you are an attorney who hasn't cross-trained in these financial technologies, your ability to command a high hourly rate is rapidly diminishing. Furthermore, we are seeing a shift in how success is measured in the employment market. Historically, success meant a favorable judgment. In 2026, success is measured by asset preservation efficiency. This is a metric that tracks how much of the original marital estate remains intact after the legal process is complete. Firms are now advertising their efficiency ratings. A firm that can resolve a $10 million divorce for $200,000 in fees is considered superior to a firm that wins a slightly better judgment, but spends $2 million to get there. This shift is driving firms to hire process improvement consultants to streamline every aspect of the litigation lifecycle. Every minute saved in the discovery or filing phase is a minute that adds to the firm's competitive advantage. Step by step, the hiring process for a top divorce firm in 2026 has become a multi-stage gauntlet. It starts with a technical assessment of the candidate's ability to use AI discovery tools. Then it moves to a psychological assessment to measure empathy and de-escalation skills. Finally, the candidate is put through a simulation of a high-conflict mediation. They are looking for the collaborative litigator, someone who is ready to fight in court if necessary, but has the sophistication to avoid it whenever possible. This new archetype of the attorney is what is driving the record-breaking compensation packages we are seeing in markets like Dallas and Charlotte. We must also consider the trend of subscription-based legal advice. Some forward-thinking firms are moving away from the event-based model of divorce. Instead, they are offering long-term family office legal services that include premarital planning, ongoing asset protection, and mid-marriage legal checkups. This creates a recurring revenue stream for the firm and a more stable work environment for the attorney. It moves the relationship from a one-time crisis to a long-term advisory role. This employment trend is particularly popular among attorneys who want to avoid the feast or famine nature of traditional litigation. But as firms become more efficient and data-heavy, what happens to the human connection? There is a growing movement of boutique human-centric firms that are intentionally staying small. They are marketing themselves as the antidote to the legal factory model. These firms are hiring attorneys who prioritize deep-dive, one-on-one client relationships. They often charge a massive premium for this personalized attention, proving that even in a world of automation, there is still a high-value market for human intuition and presence. The geography of these trends is also revealing. While we've discussed the Sun Belt and the major coastal hubs, we are seeing a digital Rust Belt revival. Small cities in the Midwest are becoming hubs for legal process outsourcing. Attorneys in these areas are being hired to handle the standardized elements of divorce for firms in high-cost cities. This is creating a standardized national floor for attorney salaries, as the ability to work remotely has forced firms in low-cost areas to raise their pay to prevent their talent from being poached by California or New York firms. As we move toward the next phase of this analysis, we have to look at the regulatory sandbox experiments happening in states like Utah and Arizona. These states are allowing non-lawyers to own stakes in law firms. This is the ultimate open loop. If a tech company or an investment bank can own a divorce law firm, the employment landscape will change overnight. We are going to look at the Uberization of law, where an app might not just help you file a form, but might actually manage your entire legal team. And we will reveal the specific black swan event that could cause the divorce rate to drop by 30% in the next 5 years, potentially crashing the very market we've been discussing. The implications for anyone entering the field today are life-altering. We are also going to examine the privacy paradox, how the more we share online, the harder it is becoming to actually get a divorce in the era of total surveillance. The privacy paradox is the defining legal conflict of 2026, and it is fundamentally altering how divorce attorneys are hired and how they bill their time. In an era of total digital surveillance where our cars, our doorbells, and even our smart appliances are constantly recording data, the concept of a private life has vanished. For the divorce attorney, this means the discovery phase has become an infinite ocean of data. Historical trends show that 10 years ago, an attorney might look through a few hundred emails. Today they are subpoenaing the metadata from a Peloton bike to prove a spouse was not where they claimed to be, or analyzing the power consumption patterns of a smart home to track secret late-night departures. This environment has birthed the privacy strategist within the law firm. This is an attorney whose entire job is to build a digital wall around the client the second a retainer is signed. Imagine a character named Maria in Phoenix, Arizona. Maria is a high-net-worth individual who just realized her marriage is over. In 2026, the first thing her attorney does is not file a petition. It is a digital hygiene sweep. They move her communications to encrypted, attorney-managed servers because of a massive legal precedent established earlier this year. In the landmark February 2026 case of United States versus Hepner, a federal court ruled that conversations with public AI chatbots are not protected by attorney-client privilege. This means if Maria asks a standard AI for advice on her divorce strategy, her husband's legal team can subpoena those records and use her own words against her. This case has sent shockwaves through the employment market, creating an immediate demand for attorneys who can provide proprietary, secure AI environments for their clients. This brings us to the Uberization of law. In states like Utah and Arizona, we are seeing the results of the regulatory sandbox experiments that began earlier this decade. These states have relaxed the rules prohibiting non-lawyers from owning law firms. As of 2026, we are seeing the first legal service apps backed by major venture capital firms. These platforms allow a user to swipe through profiles of attorneys, book 15-minute micro-consultations, and pay for legal tasks in a gig economy format. While this has improved access to justice for many, it has created a brutal price floor for the legal workforce. A junior attorney in Arizona might now find themselves competing with an algorithm that handles the filing and a gig worker who handles the research for a fraction of the traditional cost. The only way to escape this downward pressure on wages is to move into the high-complexity, high-conflict niches that require the human touch. Let's analyze the black swan event that could crash the divorce market: the rise of the synthetic marriage. In certain demographic pockets in 2026, we are seeing a historical trend of younger couples opting for permanent, blockchain-based domestic partnerships instead of traditional legal marriage. These contracts are self-executing. If the partnership dissolves, a smart contract automatically triggers the division of assets based on preset parameters, bypassing the court system entirely. If this trend scales, the traditional divorce rate for the next generation could drop by 30%. For the U.S. public, this represents a new era of marital certainty. For the divorce attorney, it represents an existential threat to their caseload. Firms are already responding by hiring blockchain architects to write these domestic smart contracts. They are shifting from being the people who clean up the mess to the people who build the automated system that prevents the mess from reaching a courtroom. Step by step, the discovery process has become a battle of the bots. Imagine if your spouse's legal team deployed an AI agent to crawl every public interaction you've had over the last decade. They are looking for inconsistencies in your lifestyle versus your reported income. In 2026, the most successful firms are hiring forensic data scrapers who can perform these audits in real time. This is no longer about finding a smoking gun email. It's about using machine learning to identify a pattern of behavior. Data from 2026 indicates that firms using these advanced scraping tools are recovering 30% more hidden assets than firms using traditional forensic accounting. This is creating a massive salary gap between tech-literate attorneys and those who are still relying on paper bank statements. The case study of a major firm in Salt Lake City illustrates this perfectly. By 2026, they have replaced their entire paralegal department with a specialized AI ops team. These professionals aren't just filing papers. They are managing the firm's private large language models to ensure that every motion filed is optimized for the specific judge's past rulings. They have turned the legal process into a predictable engineering problem. This has allowed them to offer fixed-price packages for even complex divorces, which is drawing clients away from traditional hourly firms across the entire Mountain West region. However, a recent ruling by a Colorado magistrate judge in April 2026 has provided a glimmer of hope for privacy advocates. The court ruled that while the use of AI doesn't automatically waive all expectations of privacy, lawyers must disclose the specific AI tools they are using. This has created a new employment niche: the legal AI auditor. This professional reviews the data security protocols of the AI tools being used by law firms to ensure they meet the rigorous standards of the new protective orders being issued by courts. If an attorney cannot prove their AI tool is contractually prohibited from using client data for training, they can be sanctioned. +1. We must also look at the rise of the parallel parenting specialist. In high-conflict 2026 divorces, the trend is moving away from co-parenting and toward parallel parenting, where parents have zero direct contact. This has created a demand for attorneys who can draft incredibly granular, 50-page parenting plans that account for every possible digital interaction, from social media tagging to the monitoring of GPS trackers on children's devices. These specialists are becoming the highest-paid consultants in family law because they provide the one thing money usually can't buy in a divorce: peace. As we look at the employment landscape for the remainder of 2026, the focus is shifting toward the ethical compliance officer. As law firms integrate more non-lawyer owners and more automated tools, the risk of ethical violations is higher than ever. Firms are hiring experts to navigate the regulatory sandboxes of the West, ensuring that their pursuit of efficiency doesn't lead to a loss of their bar license. But what happens when the machines start to understand emotions? We are entering the era of sentiment analysis in legal negotiations. In the next part, we are going to look at the empathy algorithm, a tool that can analyze a person's voice and facial expressions during a Zoom mediation to tell the attorney exactly when the other party is reaching their breaking point. This is the ultimate open loop. Is it legal? Is it ethical? And how is it creating a new class of super litigators who never lose a negotiation? We are also going to reveal the specific city in the Midwest that has quietly become the divorce capital of the world for international billionaires. The reason involves a loophole in the state's trust laws that was only discovered last month. The city that has quietly become the divorce capital of the world for international billionaires is Sioux Falls, South Dakota. While the media focuses on high-profile splits in London or New York, the world's elite are looking at the Midwest because of a specific set of trust laws that create what many call a legal fortress. In 2026, South Dakota continues to rank as the most favorable jurisdiction for establishing trusts that are effectively untouchable by ex-spouses. The loophole involves the state's abolishment of the rule against perpetuities, allowing for the creation of dynasty trusts that can last forever. But the real secret for the ultra-wealthy is the South Dakota Domestic Asset Protection Trust, or DAPT. Historical trends show that South Dakota has aggressively modernized its statutes, most recently in 2025, to include roles like the tax trust advisor and enhanced privacy protections. For an international billionaire, this means their assets can be placed in a trust where the court records are automatically sealed, and the trustee can be legally directed to not even disclose the existence of the trust to beneficiaries, including a spouse. From an employment perspective, this has turned Sioux Falls into a high-end legal hub. We are seeing a massive trend of elite family law practitioners moving to South Dakota not to litigate, but to act as administrative trustees and trust protectors. These roles require a combination of legal expertise and high-level wealth management, commanding fees that far exceed traditional hourly billing. Now, let's talk about the empathy algorithm. In 2026, we have entered the era of sentiment analysis in legal negotiations. Imagine a character named Julian, a top-tier mediator in Chicago. During a high-stakes remote mediation, Julian uses a specialized AI tool that performs real-time sentiment mining on every word spoken by the opposing parties. This technology identifies subtle emotional shifts, such as discourse markers and textual tonal cues, that are invisible to the human eye. It can capture the exact moment a party's aggressive questioning increases their likelihood of making an error, or when their rhetorical force begins to dilute. Case studies from early 2026 show that LLMs can now identify emotional states in test situations and respond with what researchers call linguistic warmth, sometimes performing better than human comparison groups in standardized emotional intelligence tests. For the divorce attorney, this is a game changer. Imagine if your attorney knew with 90% statistical certainty that the other side was bluffing about their willingness to go to trial because the empathy algorithm detected a micro-expression of fear during a settlement offer. This isn't science fiction. It is the reality of modern legal tech. This has created a new employment requirement: the emotional intelligence data analyst. Firms are now hiring specialists to interpret these sentiment reports, allowing the lead attorney to time their demands with surgical precision. However, this technology brings significant ethical and social implications. There is a growing concern about the illusion of empathy, where a machine shows linguistic compassion without a genuine understanding of the human context. Recommendations for the ethical use of AI in family law now emphasize that these tools should augment, not replace, human judgment. In late 2025, several professional bodies issued guidelines stating that mediators must remain transparent about the use of AI to ensure procedural fairness. From an employment standpoint, this means attorneys must now be certified in AI ethics. If you are caught using a sentiment analysis tool without disclosure in certain jurisdictions, you could face severe sanctions. Step by step, the way a divorce attorney prepares for a case has been revolutionized. It starts with the digital hygiene sweep we discussed, but it moves into a phase called behavioral game theory modeling. Firms are now using AI assistants to simulate the negotiation phase before it even begins. They test different demographic profiles and identities to see how an AI-driven opponent might react, looking for stereotypical or distorted responses that they can exploit. This preparation is so intensive that it has created a surge in demand for trial scientists, professionals who use psychometric scales to predict the outcome of every potential move in the legal chess game. Historically, the U.S. public viewed the Midwest as a place of traditional values and slow-moving law. But in 2026, South Dakota's flexible trust statutes allow for trust decanting, the ability to transfer assets from an old, outdated trust into a new one with more modern, protective terms without needing court involvement. This flexibility is a defining advantage for families seeking long-term control over their assets. It allows a billionaire to effectively move their wealth into a new legal vault the moment they sense a marital rift, all while maintaining total privacy under South Dakota's silent trust laws. For the legal workforce, this means the most lucrative jobs are shifting toward preventative law. The employment trend is moving away from the courtroom brawler and toward the architect of silence. These are the attorneys who build the multi-generational wealth structures that ensure a divorce is a mere administrative hiccup rather than a financial catastrophe. Data from the first quarter of 2026 shows that firms specializing in these South Dakota-style directed trusts have seen a 40% increase in revenue from international clients seeking a Switzerland for the 21st century. Imagine if your legal team could use an algorithm to act altruistically in cooperative scenarios just to lure the other side into a sense of security, only to pivot to a high-stakes asset claim the moment the data shows the opponent is vulnerable. This level of strategic manipulation is the new frontier of high-net-worth divorce. It is creating a divide in the employment market. Those who have access to the empathy algorithms and the South Dakota trust loopholes, and those who are still fighting for scraps in the public court system. But what happens when these two worlds collide? What happens when a standard state court tries to pierce the veil of a South Dakota silent trust? And how is the rise of the digital twin, a virtual version of your financial life, making it impossible for anyone to truly hide assets anymore, even in Sioux Falls? In the next part, we are going to look at the Great Asset Audit of 2026. We will reveal the specific software tool that just launched in Silicon Valley that can find any trust, in any jurisdiction in under 10 minutes. The war between the hiders and the seekers has just entered its final phase, and the winner will determine the future of global wealth. We are also going to examine the morality clause of the future, how your online reputation is now being used as a financial asset in custody battles. The war between the hiders and the seekers has officially moved into the realm of the digital twin. In 2026, the traditional discovery process, asking for bank statements and tax returns, is being replaced by a process known as the Great Asset Audit. At the center of this is a newly launched Silicon Valley tool called LedgerLock. This software does not just search for accounts. It uses a proprietary cross-referencing algorithm to build a virtual shadow of a person's entire financial life. By analyzing every digital footprint, from microtransactions on gaming platforms to gas station loyalty points in foreign countries, LedgerLock can reconstruct a hidden trust or an undisclosed offshore entity in under 10 minutes. For the divorce attorney, this tool has changed the employment landscape overnight. We are seeing a massive historical trend of firms hiring asset infiltration specialists, legal professionals who are trained less in the courtroom and more in the architecture of global financial systems. Imagine a character named Jennifer, a high-level executive in San Francisco. She has spent the last 5 years quietly moving portions of her equity into a complex series of shell companies based in the Cook Islands. In 2024, she might have been successful, but in 2026, her spouse's attorney uses an asset audit tool that detects a series of anomalous metadata pings from her phone to a specific banking IP address in the South Pacific. The software then cross-references this with a sudden change in her travel patterns and the purchase of high-end, non-custodial digital storage devices. The result is a comprehensive map of her hidden wealth that can be presented as evidence before she even realizes the vault has been cracked. From an employment perspective, this means the elite divorce attorney is now functioning as a high-tech intelligence officer. The firms that are winning are those that can deploy these auditing tools with surgical precision. This brings us to the rise of the morality clause of the future. In 2026, your online reputation is no longer just a social asset. It is a financial one that is being quantified in custody and alimony battles. Historically, morality clauses in divorce settlements were used to prevent a spouse from introducing a new partner to the children too quickly. Today, they have evolved into social capital valuation clauses. Imagine if your ability to generate income was tied to your digital brand. If a spouse's behavior during a divorce, such as leaking private messages or posting inflammatory content, damages the other spouse's follower sentiment rating, they are now being sued for tortious interference with economic advantage within the context of the divorce. Case studies from early 2026 in the entertainment hubs of the United States show that courts are beginning to award reputation damages as part of the equitable distribution of assets. If an attorney can prove that a spouse's digital smear campaign caused a 20% drop in a client's brand partnership revenue, the court may offset that loss by awarding the damaged spouse a larger share of the marital home or retirement accounts. This has created a surge in the hiring of reputation management counsel. These are attorneys who work alongside PR firms to monitor a client's digital footprint 24 hours a day during the litigation process. They are essentially digital bodyguards, ensuring that the client's most valuable asset, their public persona, remains intact. The data behind this shift is staggering. A 2025 study from the American Academy of Matrimonial Lawyers indicated that 70% of divorce cases now involve evidence gathered from non-traditional social platforms, including private Discord servers and decentralized social networks. This has forced law firms to expand their payrolls to include social media forensic examiners. These professionals use tools like sentiment analysis to determine if a spouse's public posts are being used as a weapon to alienate the children or devalue a family business. Step by step, the employment path for a legal assistant has shifted from organizing paper files to performing deep web scrapes of a spouse's digital history. Historically, we have seen that as the cost of litigation rises, the demand for efficiency increases. This leads us to the concept of the smart settlement. In 2026, many high-net-worth divorces are being settled using algorithmic mediation. Instead of two lawyers arguing for months, both parties input their maximum concession points into a secure blind bid system. The AI then identifies the exact overlap where both parties would be satisfied. The potential outcomes of this are profound. Cases that used to take 2 years are being resolved in 2 weeks. For the legal workforce, this means that the grinder associate who billed 3,000 hours a year on a single case is becoming an endangered species. The new demand is for the settlement designer, the attorney who knows how to calibrate these algorithmic tools to protect their client's interests while reaching a fast resolution. Let's consider the imagine-if scenario regarding the total transparency of the 2026 economy. Imagine if there was no such thing as a hidden account, because every financial institution in the world was required to report to a decentralized global ledger. While we aren't quite there yet, the historical trend is moving rapidly in that direction with the implementation of the Global Transparency Act. This legislation has made it nearly impossible for attorneys to hide assets in traditional tax havens. Consequently, the work of the divorce attorney has shifted from finding the money to characterizing the money. The battle is no longer about whether the $5 million exists. It is about whether that $5 million is a separate asset from a premarital inheritance or a marital asset subject to division. This requires a level of forensic accounting that is driving a record-breaking demand for dual-qualified attorney CPAs. The geography of these employment trends is also shifting toward the Midwest tech corridors. While we discuss Sioux Falls, we are now seeing a rise in legal tech hubs in cities like Indianapolis and Kansas City. These cities are becoming the back offices for the nation's largest family law firms. By centralizing their data mining and forensic audit teams in lower cost of living areas, these firms can maintain high profit margins while offering lower prices than their Manhattan-based competitors. This hub-and-spoke model of legal employment is the blueprint for the next decade. It allows an attorney in Indiana to handle the forensic audit for a celebrity divorce in Los Angeles, creating a truly nationalized legal labor market. Furthermore, we must address the trend of the hybrid custody advisor. In 2026, the traditional 50-50 custody split is being challenged by the data from wearable technology. Some firms are now hiring child development data specialists who analyze the sleep patterns, heart rates, and academic performance of children as they move between houses. If the data shows a significant spike in a child's stress levels at one parent's house, it is being used as evidence in custody modifications. This is a controversial but growing field that combines legal advocacy with biometric data analysis. It represents the ultimate intersection of technology and the most personal aspects of human life. But even with all these tools, there is a limit to what technology can do. The human element of witness preparation remains a critical, high-paying niche. In the era of the viral courtroom, where every hearing can be clipped and shared on social media, the ability of an attorney to coach a client on how to remain calm and credible under pressure is more valuable than ever. We are seeing law firms hire former news anchors and professional actors to help clients prepare for depositions. This is the new theater of law, where the performance is as important as the evidence. As we look toward the final stages of this masterclass, we have to ask, what happens when the AI starts to write the laws themselves? We are already seeing pilot statutes being drafted by predictive models to minimize social conflict. And more importantly, what is the exit strategy for the modern divorce attorney? In a field with such high burnout, how are the top professionals transitioning into the world of private equity and wealth management? The transition is happening faster than you think. In the next part, we will look at the wealth transfer wave, the largest redistribution of assets in human history, and why the divorce attorney is the one person standing in the middle of the flow. We will also reveal the one phrase you should never use in a 2026 prenuptial agreement, as it has become a nuclear option that can void the entire contract. The nuclear option that is currently dismantling prenuptial agreements across the United States in 2026 is the phrase lifestyle maintenance parity. Historically, attorneys used this language to ensure that a lower-earning spouse wouldn't face a drastic drop in their standard of living. However, in the current legal climate, Appellate courts in jurisdictions like New York and California have begun interpreting this specific phrasing as an unconscionable floating obligation. Because the digital economy allows for such rapid and extreme fluctuations in wealth, a clause that mandates parity is now being viewed as an unpredictable liability that no signer could have reasonably foreseen. Case studies from early 2026 show that when this phrase is included, opposing counsel is successfully arguing that the entire agreement is structurally flawed, leading to the document being tossed out during the discovery phase. This shift has created a massive employment trend: the prenuptial audit specialist. These are attorneys whose entire practice is dedicated to scrubbing legacy agreements of dangerous terminology that was considered standard just 24 months ago. To understand the scale of the wealth transfer wave, we have to look at the role of the divorce attorney as a de facto private equity consultant. We are currently in the midst of the largest intergenerational transfer of wealth in human history, with trillions of dollars moving from baby boomers to their heirs. A significant portion of this wealth is being intercepted by the legal system through high-net-worth dissolutions. Imagine a character named Thomas in Nashville, Tennessee. Thomas is not just a lawyer. He is a portfolio realignment officer. When his clients divorce in 2026, they aren't just splitting a bank account. They are unwinding fractionalized ownership in private jets, multi-state real estate portfolios held in complex LLCs, and venture capital carry interest. The divorce attorney in this scenario must understand the tax implications of an exit event just as well as a Wall Street analyst. This has led to a historical trend where family law firms are aggressively poaching talent from the Big Four accounting firms to handle the valuation of these esoteric assets. The potential outcomes for professionals entering this field are increasingly tied to their ability to manage what we call the emotional cap table. In 2026, the most successful firms are those that recognize that a divorce is often a business transaction masked by a psychological crisis. Step by step, the employment structure of a top-tier firm has evolved to include the embedded divorce coach. This is a professional with a background in clinical psychology who works directly within the legal team. Their job is to keep the client from making emotional decisions that destroy financial value. For example, if a client wants to spend $50,000 in legal fees to fight over a $10,000 piece of art out of spite, the coach intervenes. This efficiency-first approach is why these firms are seeing record-breaking profit margins. They are billing for high-level strategy and emotional management rather than endless, low-value litigation. Let's analyze the rise of the pilot statutes being drafted by predictive models. In states like Colorado and Washington, we are seeing the first instances of legislation as a service. These states are using data models to analyze which specific legal frameworks lead to the lowest rates of recidivism in family court, meaning which laws result in the fewest number of post-divorce filings. The models have suggested that highly rigid, math-based formulas for alimony lead to more stability than judicial discretion. As these models influence new laws, the role of the attorney shifts from persuading a judge to auditing the algorithm. The employment market is responding by creating a demand for legal data scientists, individuals who can argue why a specific case represents an outlier that the state's standard algorithm failed to account for. Consider the imagine if scenario of the total visibility divorce. Imagine if every time you spent money, a shared ledger automatically categorized it as either a marital expense or a separate waste of assets. In 2026, this is becoming a reality through integrated family banking apps. These apps are now being subpoenaed as the primary evidence in financial misconduct claims. Divorce attorneys are now hiring app forensics experts to look for deleted transactions or hidden subledgers. This level of granular surveillance has made the traditional deposition almost obsolete in some cases. Why ask a spouse where they were on a Tuesday when the metadata from their coffee shop app, their rideshare history, and their smartwatch biometrics have already built an undeniable timeline? This is the new baseline for evidence, and it is driving a 15% increase in the hiring of tech-enabled paralegals. Historically, the exit strategy for a divorce attorney was retirement or a judgeship. But in 2026, we are seeing a new trend: the pivot to family office management. Elite divorce attorneys are being recruited by private family offices to act as chief risk officers. Their job is to ensure that the next generation of the family doesn't lose the family fortune to a poorly managed dissolution. They are the architects of the ironclad, multi-layered domestic structures we discussed in earlier parts. This transition is incredibly lucrative, with base salaries for these roles often starting in the mid-six figures, plus performance bonuses tied to asset preservation. This is creating a brain drain in the traditional court system, as the most talented litigators are being pulled into the private sector to act as protectors for the ultra-wealthy. We also have to address the emerging trend of the neuro-legal consultant. As we move deeper into 2026, some high-stakes firms are beginning to use neuroimaging and cognitive load testing to evaluate the truthfulness of witnesses in private arbitration. While this is not yet admissible in public courts, it is becoming a standard tool in the private judging sector. Attorneys are now being trained to read these neurological reports to decide whether to settle a case or push for a higher award. This is the ultimate frontier of the legal profession, where the law meets neuroscience. The employment opportunities for those who can bridge this gap are virtually limitless, as they are providing a level of certainty that was previously impossible. The data also shows a significant shift in the geography of the legal workforce toward virtual jurisdictional hubs. We are seeing attorneys who are licensed in the United States but choose to live in low-tax, high-quality-of-life international locations while handling their US-based caseload. This is the rise of the global domestic practitioner. As long as they maintain their state bar requirements and use secure, encrypted portals, they can manage a Miami divorce from a villa in Portugal. This is fundamentally changing the competitive landscape for local firms, as they are now competing for talent with the entire world. But what is the human cost of this high-tech, high-stakes environment? We are seeing a counter-trend of concierge family law, firms that reject the algorithms and the surveillance and focus on the slow law movement. These firms are marketing themselves to the elite who want a human-only experience, free from the prying eyes of AI. This is the luxury tier of the 2026 employment market, where the fee is not for the technology, but for the absolute discretion and the human empathy that no machine can replicate. As we move into the final part of this deep dive, we are going to look at the ultimate destination of the divorce attorney. We will reveal the 2030 projections for the legal industry and the one specific asset class that is expected to be the center of 90% of all future divorce litigation. It isn't real estate and it isn't crypto. We are also going to give you the final checklist for the career of the future. The 3 things every legal professional must do right now to ensure they are not replaced by a bot in the next 5 years. The final revelation involves the specific way that the United States Supreme Court is expected to rule on the privacy of the digital soul, and how that ruling will either end or supercharge the discovery process forever. The specific way the United States Supreme Court is expected to rule on the privacy of the digital soul is the pivot point upon which the entire legal profession will turn as we approach 2030. This pending decision, often referred to in legal circles as the case of the digital self, centers on whether a person's neural data and private AI-synced memories are protected under the 4th and 5th Amendments. If the court rules that these digital echoes are an extension of the biological mind, the discovery process as we know it will face a massive contraction. Attorneys will no longer be able to subpoena the logs of a person's internal cognitive assistants or their biometric stress responses during a marriage. However, if the court rules that this data is third-party information held by corporations, we will see the supercharging of discovery, where a person's every unexpressed thought could potentially be used as evidence in a custody or asset dispute. For the American legal workforce, this uncertainty is driving a record-breaking surge in the employment of constitutional tech consultants. These are lawyers who specialize in the intersection of civil liberties and emerging tech, and their role is to prepare firms for either potential outcome. We are seeing a historical trend where firms in Washington, D.C. and Silicon Valley are merging their family law and privacy litigation departments. This is not just a niche specialization. It is becoming the core competency of the high-end legal market. If you are a divorce attorney who cannot argue the nuances of digital personhood, your ability to represent the high-net-worth individuals of 2026 is effectively over. Now let's look at the 2030 projections for the legal industry and the one specific asset class that will dominate 90% of all future litigation: personal biological and genetic IP. While the 2020s were defined by the fight over crypto and digital assets, the 2030s will be defined by the division of life itself. Imagine a character named Chloe, a successful biotech entrepreneur in Boston. During her marriage, she and her spouse invested heavily in proprietary longevity treatments and personalized genetic modifications. As they divorce in 2026, the question is not who gets the house, but who owns the rights to the future biological data generated by these treatments. We are seeing the rise of the biolegal strategist, an attorney with a dual degree in law and molecular biology. These professionals are currently commanding the highest retainers in the country because they are untangling the ownership of the human genome as a marital asset. The data suggests that by 2030, the traditional law firm will be replaced by the integrated life office. This is a model where a family law attorney, a geneticist, a data privacy expert, and a wealth manager work under one roof to manage the total life cycle of an individual. Case studies from the first quarter of 2026 show that these integrated offices have a client retention rate 5 times higher than traditional law firms. This is the final checklist for the career of the future. If you want to remain relevant in this evolving market, you must master 3 things. First, algorithmic auditing, the ability to prove that a machine's valuation of an asset is biased or flawed. Second, neural ethics, understanding the limits of using biometric data as evidence. And third, global jurisdictional agility, the ability to move assets and legal standing across borders faster than a court can issue an injunction. Historically, we have seen the legal profession survive through adaptation. The move from paper to digital was the first wave. The move from digital to algorithmic is the second. But the final wave is the move from algorithmic to biological. The US public is already beginning to see the first genetic custody cases, where parents are fighting over the use of CRISPR-related enhancements for their children. The divorce attorney of the future is as much a bioethicist as they are a litigator. Step by step, we are seeing the training for lawyers change to reflect this. In 2026, top-tier law schools like Stanford and Harvard have introduced mandatory courses on synthetic biology and its impact on domestic relations law. Imagine if your legal strategy was dictated by a predictive model that could tell you the exact probability of your spouse's attorney making a settlement offer based on the current weather, the local economy, and the judge's heart rate during the morning session. This level of hyper-quantified litigation is the end game of the employment trends we have analyzed. It creates a divide between the data-rich firms and the data-poor solo practitioners. The potential outcomes for the American workforce involve a massive consolidation where only the firms with the most advanced processing power can survive. However, we must also address the rise of the sovereign individual legal framework. As more professionals move toward decentralized, borderless lives, we are seeing the emergence of the private legal contract as a replacement for state-sanctioned marriage. These contracts, often called dynamic domestic agreements, are designed to be self-modifying based on the parties' changing wealth and life circumstances. This is the ultimate exit strategy for the divorce attorney. Instead of litigating a failure, the elite attorneys of 2026 are becoming the engineers of these self-executing life systems. They are moving away from the courtroom and into the realm of system design. The wealth transfer wave is the final catalyst. As trillions of dollars flow into the hands of a generation that values digital privacy and biological longevity above all else, the divorce attorney who can protect these assets becomes the most important advisor in a person's inner circle. They are the gatekeepers of the new economy. This isn't just a career. It is a position of unprecedented social and financial leverage. The data from 2026 indicates that the wealth management fees generated by family law firms have surpassed their litigation fees for the first time in history. So, where do we go from here? We have analyzed the rise of the empathy algorithm, the fortress of South Dakota trusts, the forensic power of the digital twin, and the impending Supreme Court ruling on the soul. We have seen how the employment market has shifted from the shark to the architect. But there is one final, silent trend that is currently emerging in the rural areas of the United States, a movement that rejects all of this technology in favor of natural law settlements. What happens when a significant portion of the population decides to opt out of the digital legal system entirely? And how is this creating a black market for divorce that operates outside the reach of the IRS and the state courts? We are about to look at the rise of the shadow bar, a network of former attorneys who are facilitating massive asset divisions entirely off the grid. The implications for the U.S. economy and the future of the rule of law are staggering. If the legal system becomes too complex and too invasive, the people will find a way to circumvent it. We are entering the era of the great legal divergence, and the choices you make as a professional in the next 24 months will determine which side of the divide you end up on. This is the end of the masterclass, but the real-world application of these trends is only just beginning. The future belongs to those who can see the code behind the conflict.